Andrea McNamara is going to talk to us in a moment about succession planning and all the associated topics of that, including tax planning. Andrea is a solicitor with O'Connell Brennan in Dublin, and she is a STEP committee member. Clare McGuinness is going to talk to us from looking at the revenue, the appeals, the dealing with revenue. Clare works as a tax consultant with Ronan Daly German in Dublin, and she works closely with revenue, and she set herself on matters post the event, when things have gone wrong. So it'll be interesting to hear from her. Andrea's just asked me to mention before we start the STEP annual conference, which is a great day for any of you who have been there or may not. It's a great event in Dublin. It's on in the Hilton Hotel in Charlemont Place in Dublin on the 11th of May, which is a Friday, and it's open to both STEP members and non-STEP members, and for anyone who practices in this area. It's well worth attending. So the details will be on their website, which is step.ie. So I'm conscious that we've started a little bit late, so I won't take up any more of your time, and I'll hand over to Clare, who will speak to you now.
Good afternoon and welcome. It's great to see such enthusiasm for tax on a Friday afternoon. I'm going to give you a brief overview of what you do.
Can't hear you.
Is that better?
No.
Now? Great. Okay, so I'm going to give you an overview of what you do if something goes wrong with revenue. So if you file a tax return on behalf of your client, and then you receive a letter querying issues in that return. So what options are available to you if it happens that a tax default is discovered? How can it be corrected, and what is the position regarding interest and penalties? I look at the changes that have been introduced in Finance Act 2017 in respect of offshore assets. So how does this impact where offshore gifts and inheritances have been received? I look at the definition of cooperation in the context of penalties and how cooperation can impact on the level of penalties that will apply to any tax which is incurred. And then I look at the Tax Appeals Commission. A new Tax Appeals Commission was set up in 2016, and it deals with the appeal of any assessments to tax which have issued. The Tax Appeals Commission is now required to publish their determinations on their website, and I look at some risk determinations that have been published. So then, if you receive a letter from revenue, the first thing to do is to see what type of intervention is it. There's three categories of intervention. There's the non-audit intervention, which I would say is the less serious. There's a revenue audit, and then there's an investigation, which is at the other end of the scale, which is where revenue believe that there's some sort of fraud which has been committed. The most likely type that you will see is the assurance check, or the non-audit or a revenue audit. And an assurance check or an asset query will frequently be raised where you filed a tax return claiming a credit or relief. So if you claim a dwelling house relief on a cash return, revenue are likely to look for documentation supporting that claim. And usually when you receive one of these letters, it will be because either you claimed relief or they've identified that there's a risk there. So they believe that there is an issue in terms of the underlying return which has been filed. So if you receive one of these, there is an opportunity to correct an error which has been made. You're not in a revenue audit run at that stage. A revenue audit means that they're going to conduct a full examination of the tax return, and they can do that either by coming out to the office or to the taxpayer's premises, or they can do it by means of desk audit by post, where they'll just ask you to send the information in to them. And then a revenue investigation is, as I said, at the other end of the scale, where they believe there's tax fraud has been committed. So the consequences then of an assurance check or an asset query. If a tax default is discovered, there's still the possibility to remedy it. So in order to remedy it in the least, I suppose the least costly way, You can do that by means of claiming innocent error, technical adjustment. You can make an unprompted qualifying disclosure, and by providing full cooperation. And I look at each one of those in turn. If it's a revenue audit that has letter that has issued, then you can make a prompted or an unprompted qualifying disclosure. And an unprompted disclosure can be made any time up until the audit commences. So, if you discover an error in a return and revenue hasn't contacted you, then you can self-correct that return. And self-correction doesn't attract any penalty. There's also other methods by which you can correct a default, and that's by claiming innocent error, technical adjustment, and qualifying disclosure. And I'll look at each of those in turn. So, self-correction, as I said, is where there's no contact whatsoever from revenue. So if you go back and you were looking at the return that was filed and you see there's a typo in it or there's an error in the return, then you can go back to revenue if the return was filed in the last 12 months and you can correct that error. And what you need to do is you need to submit a computation and to notify revenue in writing or via their revenue online service. And the tax and the interest that is due on the underpayment has to be paid. No penalty will apply, but interest does apply to any default. So innocent error can be claimed. So if a tax default is discovered and it was simply a mistake that wasn't delivered and it's not attributable to any failure by the tax return taxpayer to take reasonable care, then you can claim that it was innocent error. This is more aimed at the smaller defaults. So previously in the Code of Practice there was a cap of €6,000 on the amount in respect of which innocent error could be claimed. So if the default was €6,000 or less, innocent error could be claimed in respect of that default, so no penalties would be applied. What revenue do now is they look at whether the default was material in the context of the taxpayer's overall tax payments. So is it material for that taxpayer as opposed to a monetary cap on it? They're looking at the overall tax payments of that taxpayer. And they'll also look at the compliance history of the taxpayer. So is this a taxpayer who's had frequent issues? And if so, they're less likely to be able to claim the innocent error. Interest again applies, but no penalty will apply if revenue accepts that it was an innocent error. Technical adjustment then arises from differences in the interpretation or the application of the legislation. So this is where, I suppose, you've interpreted the legislation and you believe that you've applied the legislation correctly and that the tax that's paid in the return is correct in accordance with the legislation. And revenue come along and they say, well, no, we don't agree. If the matter is eventually found in favour of revenue may allow technical adjustment where they believe that due care has been taken and that there is a mistaken interpretation of law and practice which did not involve deliberate behaviour. So what you're looking at here is whether there is any court decisions out there or published appeal commissioner decisions which would be in favour of the approach that you've adopted. Was there accountancy or legal or tax advice which was obtained which would support the approach adopted in the tax return? Just one point, if there is an extremely complex transaction and revenue believe that the complexity of the transaction was for tax avoidance purposes, then they have said that they won't allow technical adjustment in those circumstances. Statutory interest again will apply, but no penalty will apply where successful in claiming technical adjustment. The next option then is qualifying disclosure. And a qualifying disclosure is the disclosure of full particulars of the matter giving rise to the tax liability. It must be in writing and it must be signed by or on behalf of the taxpayer. And in reality, it should always be signed by the taxpayer, because as part of the declaration which must be submitted to revenue, the taxpayer must declare that to the best of their knowledge, information and belief, the matters contained in the disclosure are correct and complete. So that's not a declaration that anybody but the taxpayer should be making. The payment of the tax and duty and interest on the late payment has to accompany the disclosure. And if there is an issue regarding payment and that the taxpayer doesn't have the funds to make full payment, then it's important to engage with revenue to see if a payment arrangement can be entered into, because one of the requirements for a qualifying disclosure is that full payment is made. And it may be possible to get around that where bona fide payment arrangements are entered into. So, as I said, qualifying disclosure can be prompted or unprompted. And an unprompted disclosure can be made any time before an audit notice is received, whereas a prompted disclosure is made in the period between receiving the audit notice and the date in which the audit starts. Why would you make a qualifying disclosure? A qualifying disclosure means that the taxpayer has reduced penalties, they have an assurance in respect of non-prosecution, and there's no publication on the list of tax defaulters. So those are the key benefits of making a qualifying disclosure. Finance Act 2017 amended section 107.7e of the Taxes Consolidation Act and paragraph 310 of the Code of Practice, which governs how revenue carries out their interventions. What it basically has done is it said that where a client has offshore assets or income and they haven't declared those offshore assets or income to revenue, then they can no longer make a qualifying disclosure to revenue. So in terms of any default that may arise or any tax liability they may have for that offshore income or gains, that means that they can no longer have the benefits of a qualifying disclosure. So they're open to potential publication on the list of tax defaulters, higher penalties and potential prosecution. The definition of offshore is extremely wide in that it includes any jurisdiction which isn't Ireland. So we're looking at assets held in the UK, in the EU, anything outside of Ireland. So who do these changes affect? The changes affect basically anybody who has assets or income outside of Ireland. But if we look at an Irish resident, but a non-domiciled individual, so they are likely to hold investments abroad, and they're also more likely to have received fixed or inheritances outside of Ireland. So the question is, have those been declared? Non-Irish citizens who moved to live and work in Ireland, and again, they're more likely to continue to hold assets outside of Ireland. Irish residents who may have omitted to declare an asset they held outside of Ireland. So offshore property, foreign pensions. There was an offshore asset disclosure incentive held last year, and these are the top sources of income and gains that were declared in that incentive that hadn't previously been declared to revenue. So foreign pensions, and this is where we're looking at somebody who may have worked abroad for a certain number of years, and they have a pension from that employment. And they may, for whatever reason it may be, have never declared that here. So they're now no longer able to make a qualifying disclosure in respect of that income. Holiday homes, which they may have a holiday home in Spain that they decided to rent for a certain number of months in the year and it wasn't being used, and they may not have declared that income here. Foreign bank accounts, shares, so shares that an employee may have got in their employer company and may not have realised that those shares are actually shares in a foreign company, and that they were employed by a multinational. And then investment portfolios, which would frequently have assets and shares in foreign companies. So all of those types of properties and income sources. Where those arise, then I suppose the client is limited in terms of the options available to them, where a tax default has happened and they haven't reported that income to revenue. So where are you likely to come across this? In terms of preparation of wills, where you're asking for a schedule of assets, and you're looking at assets which appear, which are outside of Ireland. So the question to be asked is revenue aware of these assets? Now, in terms of deceased taxpayers, penalties don't apply. However, frequently what will happen is if you've got a holiday home, that holiday home may be held by jointly or by multiple people. And in terms of cash returns, prior article benefits, this is something that revenue are looking at frequently in terms of there may have been no cash return required in respect to the earlier benefits because they were under the 80% threshold. But what are those benefits? And were they income or gains earned abroad? So, as I mentioned at the start, the potential risks then, where an offshore liability is discovered, is that no qualifying disclosure can be made. Increased penalties will apply, and that means that there's the potential for publication on the list of tax defaulters, and then potentially prosecution if an approach isn't made to revenue. Just the final slide there on offshore liabilities. As I said, no qualifying disclosure is possible. There is an out where the liability is quite small. So if the aggregate tax default is €6,000 or less and there's no deliberate behaviour, then no penalty will apply. And what you will be looking at is if it's greater than 6,000, can you fit it within those other options of self-correction or innocent error or technical adjustment? Is there some way of getting around the qualifying disclosure category so that the matter can be dealt with in a way that there's the least exposure for your client? Just in terms of an offshore liability, where an offshore liability arises, it means that your client can't make a qualifying disclosure in respect of their domestic liabilities either. So they may have a small offshore issue, which means that their tax issues within Ireland cannot be resolved because of this offshore issue that they hadn't realised up to now was going to prevent them from making a disclosure. So I've included the penalty table there of the various categories which revenue look at in terms of the penalties which will apply to a settlement. So when you're looking at a potential liability, penalties up to 100% apply to any tax which is being underpaid. That penalty can be mitigated based on the type of default which has occurred. Was it deliberate behaviour or was it careless behaviour? And then in terms of what was their disclosure made. So was there an unprompted disclosure or prompted disclosure, or was there no disclosure made? And then finally they can be mitigated if full cooperation is provided to revenue. And the key part is the full cooperation on your part is where I suppose you can influence the outcome of any dealings with revenue. And full cooperation has been defined by revenue. It's been defined in the negative, in that they've provided examples of what they believe is a failure to cooperate fully. And what they consider as a failure is failure to communicate with revenue in a timely and responsible manner, a failure to meet agreed deadlines, and a failure to reply to their queries on a timely basis. So as you can see, they're all quite subjective in terms of what it's what revenue believe, whether or not you are cooperating fully with them. And I suppose how they deal with the matter depends on whether there's an agent in that the client is dealing with revenue directly or non-agent cases. What I would say in terms of cooperation is that if there is a delay in responding to revenue, that you need to be clear with revenue the rationale for that delay. So if revenue have requested a response to a letter within 28 days and it's not possible to respond within that time limit, you need to be writing to revenue saying, I have written to X, Y and Z requesting documentation. Once I receive that documentation, I will respond to you fully. And if there's a delay again, then you need to be writing to them again, because the key to any objections regarding the level the penalty which is applied is that you can document fully that you took all the steps necessary at the different stages. And at the end of this is the fact that if revenue say you haven't cooperated, that's additional cost for your client in terms of the level of penalty which can be applied. And the only redress there is, if revenue won't agree with you, is to take the matter to the courts. So automatically there's going to be a cost to that, and that means that the matter will be dealt with in open court, which a client is not going to thank you for. So if I look at some of the frequent issues that revenue are raising in terms of cash, firstly, in respect of discretionary trusts, what they're looking at is where discretionary trusts have been created under a deceased will. They are increasingly writing to executors where such trusts have been created, and this is arising from the fact that there's increased interaction between the probate office and revenue as a result of the systems they've now put in place. In terms of dwelling house exemption, they're looking at the availability of dwelling house exemption where a beneficiary receives a specific bequest of a property in addition to an interest in the residue which contains another residential property. And there's been a recent appeal commissioner's determination on this issue, which I'm going to take a look at just a little bit later. In general, as I was saying, they're looking at hard benefits which are declared in CAT returns. So where the exempt threshold, the group threshold wasn't exceeded by 80%, they will now look at what was the source of those gifts and were they accounted for properly, and they'll be looking for documentation to support those. In terms of business relief, in addition to the valuation of the businesses, what they're looking at is whether the property continues to be relevant business property after the 6 years. So they will come back a few years after the business relief has been claimed to ensure that a clawback hasn't arisen and that property continues to qualify for the relief. Then on favourite nephew relief, they're looking at proof that the beneficiary worked substantially on a full-time basis for a defined period. And again, I think things like that can be very difficult to prove in terms of how do you show that you substantially spent the time working in the business. And I think it's something when you are claiming it in return, you need to be documenting with your client what work he has outside of the business. Is he in employment and does he physically have the hours to spend in this other business? If he wasn't working on it full time, then how can we satisfy revenue that he fulfills the requirement of having substantially worked on a full-time basis over the period? In terms of valuations, revenue has said that in the absence of supporting documentation, a professional opinion will not itself prevent the application of penalties. So what we're back?
Yeah.
We're back. Okay, so in the absence of supporting evidence, revenue, they won't take a professional opinion at face value. So we're looking at if an exceptionally low valuation is received for a property. Okay. If they receive a valuation which they believe to be incorrect, and that it is okay, so can you hear me if revenue receive a valuation that they believe is out of kilter, so they believe that it's exceptionally low, they won't accept that opinion at face value. So really what you need to be doing is you need to be getting at least 2 valuations, I would say. And if you believe that they aren't reflective of the value, I suppose the easiest thing to do is go to the property price register. And if there is a valuation that, or if there's been property which has recently been sold, which matches the valuation that you received for a neighbouring property, then that should satisfy revenue if the properties are similar to each other. If there's a valuation or a property which has been sold, if there has been a property which has been sold and thus far higher in value, then you need to be recording why is that property, why is the property that you're dealing with of a lesser value. So is there a difference in the properties? Is it a much smaller property, or is there something affecting the property that would mean that the value is substantially less than the neighbouring property which has been sold? Several penalties apply for undervaluations, and basically they're calculated depending on the level of the undervaluation. So if you move on then to the Tax Appeals Commission. So the Tax Appeals Commission deals with the appeal of tax assessments. So where it's not possible to reach a settlement with revenue, and they issue an assessment. The appeal of that assessment goes to the Tax Appeals Commission. A new Tax Appeals Commission was set up in March 2016, and the appeals are read directly to the Tax Appeals Commission rather than revenue. Previously, what happened was you submitted your appeal to revenue, and revenue then sent it forward to the appeal commissioners. There's 2 permanent appeal commissioners which are dealing with the current appeals, and there's a temporary appeal commissioner which is dealing with the backlog of appeals which are in the system from prior to 2000 and from prior to March 16. There's a 30-day time limit for the making of appeals, and the TSC has now a sole responsibility to decide whether to accept or refuse an appeal. An appeal can be refused if a tax return hasn't actually been lodged for the event. So if revenue are claiming that, if revenue are claiming that there was a disposal and there's no underlying CGT return that was actually lodged, then that CGT return needs to be lodged, even if it's a nil return, before an appeal can be filed. And if there's tax due per the return, that also has to be filed in order to ensure that you have a valid appeal. There's no right of rehearing for taxpayers before the Circuit Court. So the only option of appeal is appeal on a point of law to the High Court. So the key, I suppose the key point in any hearing before the Tax Appeals Commission is this is your one chance to actually establish the facts. There is now publication of determinations on the Tax Appeal Commission's website. There has been limited determinations published to date, but going forward we would hope that there will be more. Public hearing is the default position, but you can elect to have the hearing held in private. So when you're filing a notice of appeal form, I think in most instances a client will want to have the appeal heard in private. And the determination of matters under appeal without hearing. This, I suppose, was a change in the new legislation, in that what it says is that the Tax Appeals Commission can now basically apply the doctrine of precedent to its determinations. So where they have an appeal coming in and they believe that it raises common and related issues to a determination that they have already made, then they will send a copy of that determination to the appellant and to revenue, and they will set out the fact that they intend to apply this determination to the facts at hand, and there's an opportunity to object, but the Appeals Commission don't have to abide by those objections. So it may be that an appeal is actually determined without a hearing, and the only appeal per se that can be made of that decision is by way of judicial review to the High Court. So the notice of appeal form. So this is the first form that you're required to fill out once you receive your assessment, and it's filed directly with the Tax Appeals Commission, either by email or post. The notice of appeal form, I suppose it's quite a detailed form in that you include details of the amount, the tax type and the amount of issue, but you also, at this early stage, you also need to include details of the relevant legislation, the case law and the grounds of appeal. And the grounds of appeal need to be very detailed in terms of what is it exactly that is at issue, and what, I suppose, basically it's a complete outline of what your case will be at the appeal, and you may be restricted at a later stage from raising further grounds of appeal. A copy of the assessment has to be included also, and also you need to submit an authority from your client that you're acting on their behalf. So if I just go through the procedure at the Tax Appeals Commission, then once you submit your notice of appeal, you must do so within 30 days of the issue of the assessment, and then the notice of appeal is sent by the Tax Appeals Commissioner to the Revenue. Revenue can object to the notice of appeal on the basis that it's not a valid appeal, so that a tax return hasn't been filed or the tax due hasn't been paid. Revenue can either, or the Tax Appeals Commissioner can then either accept or refuse the appeal. If they refuse the appeal, your only option is judicial review. If they accept the appeal, then you're into the appeals process. So the next step in the process is a statement of case will be provided by both parties, and usually it will be requested from the taxpayer first. And I suppose this can give rise to difficulties where it's not entirely clear what Revenue's case is, and I suppose there's an unbalance in favour of Revenue, in that the onus of proof is on the taxpayer. So the taxpayer can be left in a position where they've been issued with an assessment, they're not entirely certain where the basis of this assessment is coming from, and then they're asked to prepare a statement of case for submission to the Tax Appeals Commission. So as part of that process, it needs to be very clear that if you're not aware of the basis of the revenue assessment, that this is specifically stated in the statement of case, and that you reserve the right to come back and state further grounds of appeal once Revenue's case has been made clear. Following the statement of case, at any point in the process, really, a case management conference can be held, and the purpose of this is basically, I suppose it's like a case management hearing, is to determine are the sides ready to go to hearing, or is this a matter that may be settled in advance for hearing. Legal submissions are then usually requested before the actual hearing. And at any stage in the process, the appeal commissioners can decide to adjudicate without a hearing once they've written to both sides indicating this intention. Following the hearing, a determination will issue, but there's no timeline on that determination issuing. Currently, we've had a case that was heard in March 16, and we're still awaiting determination. There's been, I think it's 34 determinations published so far since 2016, so there's quite a backlog in the system. There's currently case management hearings being held consistently in respect of legacy cases, and these are cases where the appeals relate, I suppose the appeals or the assessments would have issued prior to 2016, but many of the tax years under appeal are for years, it could be prior to 2010. So there's a huge issue regarding interest and penalties in respect of any of those appeals. The determinations, I suppose, once they're handed down, then there is a time limit in which they have to be published on the website within 90 days. And the determination can be appealed to the High Court by way of case stated, or there could be a judicial review. Just as I was saying, there used to be an opportunity to appeal to the Circuit Court, but that has now been removed, so there's no opportunity for a rehearing. So your tax appeals hearing is your only opportunity to establish the facts in the case. So then if I look at some of the appeal commission determinations which have been published in respect of capital taxes, the first one there is dealt with dwelling house exemption, and it involved a bequest of a family home, and there was 4 other properties which passed under the estate. So the clause under the will provided, I give, devise and bequeath all of my property of every nature, description and kind, wheresoever situate, to my son and daughter in equal shares for their own use and benefit absolutely. So there was a family home and an interest in 4 of the properties, and there was also additional business properties, or a business which passed under the will. And a deed of family arrangement was ultimately entered into so that the daughter received the family home and an interest in the 4 other properties. Revenue issued an appeal. She claimed dwelling house exemption and that she had occupied the family home up to the point of death, and she satisfied the requirements in that regard. But Revenue contended that all of the properties transferred on death formed part of the residue of the estate, and that they were all inherited at the same time, and therefore dwelling house exemption could not apply. The Tax Appeals Commissioner found that the legal test contained in section 86, namely whether at the date of the inheritance the appellant was beneficially entitled to any other dwelling house or to any interest in any other dwelling house. And what they said was, at the date of the inheritance, she wasn't beneficially entitled to the 4 other dwellings. She didn't become beneficially entitled to those until the residue was ascertained, and that was some months later. So at the point of the date of the inheritance, when her father died, she didn't have a beneficial interest in those properties. So I suppose it's a very interesting case, but it has been appealed by Revenue to the High Court, and it will be interesting to see is it settled in advance or if it actually goes to a full hearing. The next case deals with the CAT-CGT set off under Section 104 of the CAT Acts. So this case involved the sale of agricultural land, and agricultural relief from CAT had been claimed in 2011 when the land was inherited. In 2015, the agricultural land was sold, so it was sold within the 6-year time period of the inheritance. CGT arose in the disposal, and there's also a clawback of the CAT. So the taxpayer in this case claimed that the CAT-CGT set-off arose because the CAT and the CGT arose on the same event, i.e. the sale of the land. However, Revenue contended that that it's 2 separate events, in that the CAT arose on the inheritance, not on the disposal, and that what it effectively was a clawback, but that it was not the same event. And TAC agreed with Revenue, and they said that the clawback isn't an event for the purposes of the set-off, and the disposal in 2015, even if it was an event, that it wasn't the same event that was giving rise to the tax charge to the CAT as was to the CGT. So the next case then deals with the exemption under Section 564 of the Taxes Acts. which relates to the disposal of woodlands. So in this case, the taxpayer received consideration from an energy company, and what he had disposed of was a series of rights allowing the company to erect pylons on his land. As part of the deal that was reached, there was an agreement. The lands were under forestry, and as part of the agreement, he agreed that he would clear the trees. So he claimed that relief was due, and that part of the consideration he was receiving was attributable to the disposal of those trees. And the TAC determined that the section requires the underlying land to be fully alienated in the disposal in order to avail of the exemption. So basically what they said here was he wasn't disposing of the woodland, he was basically disposing of trees and nothing else, and that the grant of an easement does not comprise of a disposal of woodland. And it was what was key here is what they were considering, was this a license he was giving to the energy company, or was it an easement? And they said that even looking at it from the most advantageous viewpoint for the taxpayer, and if we said it was an easement, even that wasn't sufficient to be described as a full disposal of the underlying land. So then the next case involved the definition of what was consideration in respect of a gift. So what this case involved was it involved the inheritance of a property by siblings, where one sibling lived on that property for several years. The property was subsequently sold, and one of the recipients received a cash gift from their sibling. That sibling claimed that the value of that gift should be reduced because I allowed him to stay in that house rent-free for 9 years. Revenue appealed this, they didn't agree, and the TAC agreed with Revenue's approach. The final case then deals with the availability of business relief. And this involved a pharmacy which had the pharmacy on the ground floor, and then there was an upstairs above the pharmacy. And Revenue claimed that was the ground floor where the pharmacy business was carried on may qualify as an asset for the purpose of business relief. The first floor didn't qualify. But the issue in this case was Revenue didn't put forward any evidence to support their view, and the appellant put forward evidence which basically showed that the first floor was used as a storage unit. It was used by employees to store bikes. It was used to make phone calls, and there was washing facilities there. So I suppose what was interesting in this case was Revenue, or the TAC, found in favour of the appellant, and what they said was if Revenue isn't going to put forward any evidence to corroborate their view, then they've no option but to find in favour of the taxpayer. And it is interesting in terms of the burden of proof being on the taxpayer, and usually you'll find yourself in the difficult position that Revenue can effectively, well, in the past they could effectively sit back and say, well, you have to prove that we're not right. Whereas this case, I suppose, is interesting in that TAC is saying that there is a positive obligation on Revenue to prove that they have evidence contrary to what the taxpayer is putting forward. So I hope you found that interesting. If you have any questions, we're going to take them at the end.
Thank you, Chair. Chair said just for purposes of continuity, we will take the questions at the end. So if we'll have, more technical work. Andrea is going to speak to us now about the succession planning and all the various issues involved. So, thank you, and I'll pass you over to Andrea.
You some gentlemen. You like you gentlemen.
Thrown out the window after being severely beaten up by a mob. I'm going to give up to Julie yeah, I was going to say that. That's exactly what I was saying. I probably wouldn't be thrown out the window anyway. This was found on the side street near Imperial Hotel. I remember the flume against the guardians and so he said.
Good afternoon, everyone. As Claire said, it's lovely to see such a large crowd here on Friday afternoon, particularly. So I hope you'll enjoy my talk. I'm going to speak to you today about succession planning. Sorry, one moment. Sorry, just one moment.